Part 4 and final, continuing and completing my Twitter video statement to the U.S. Senate as a judiciary body on January 6th to sit in judgment of an election contest filed against Senator Al Franken. Under the U.S. Constitution, Article 1, Section 5, Clause 1, you must act as the sole judges in a judicial capacity to decide whether or not to seat Al Franken based on an invalid election in Minnesota in 2014. He should not be seated because his selection was a result of serious, material, and deliberate violation of provisions of Minnesota election law, including the U.S. Constitution, including an absolute abdication of responsibility by the Minnesota courts, and this is the focus of Ground 4. As I detail here, the refusal by the Minnesota Supreme Court to hear a petition to enforce the right of a major political party nominee is something new. It is already well established in Minnesota election law, judicial precedent, that the Minnesota court has jurisdiction and authority and must hear cases during the election to enforce First Amendment rights and equal time requirement law. That's Michael Moore, the U.S. Senate nominee of the IP in 2002, could not assert an equal time claim, though, because he did not exhaust administrative remedies by getting an FCC disposition. But I did that. I was able to be excluded from all debates based on a 2002 decision by the Ramsey County District Court against the Independence Party Senate nominee Michael Moore in Michael Moore versus NPR, the same public radio outfit who excluded the Independence Party in 2014. Had NPR not excluded IP in 2002, there would not have been a precedent for getting rid of the party altogether by excluding us from public broadcast debates in the heat of the election. Judge Monahan of the Ramsey County Court acted under 209B.44, providing for election petitions, the same one I filed in 2014, regarding the exclusion of from the WCCO and NPR debates, which the Minnesota Supreme Court refused to act on. Because the Senate is a statewide office, the Senate race, it should have been brought to the Supreme Court, not the county. Otherwise, the jurisdiction was exactly the same. However, by 2012, the issue of whether NPR could exclude IP, and that's actually 2014, could exclude IP from a Senate debates was supposedly no longer included, only ballot-related questions. That violates the U.S. Constitution, as I will carefully explain. But to make it simple, the Minnesota legislature, the Minnesota courts, and the Minnesota executive branch are all bound in their state action or inaction to laws that are prescribed. That means written and established before the election begins and lasting until after the last election contest ends. And all state actors in the election must follow these prescribed rules. And that is why in 2002, a counseled IP Senate candidate brought a case to the Ramsey County Court under 204B.44 election remedies to be used to enforce election law during the election to get in the candidate debates with Mondale and Coleman. And he got a ruling. The irresponsibility of the Minnesota Supreme Court in refusing to hear and decide whether Senator Franken could lawfully schedule the exclusion of the Minnesota Independent Party nominee for all the publicly so-called U.S. Senate candidate debates is extraordinary. It is a flagrant departure from the Moore versus NPR case. Minnesota clearly is bound by the First Amendment in enforcing U.S. Supreme Court precedent in the election of members of Congress. Perhaps not for state offices. I have not studied that fully. I have cited Saari versus Gleason, a state case, which is a leading case for Minnesota regulation of elections, and the setting aside of invalid elections like this one. That case reaffirmed in Pavlak versus Crow is a good guide for this body of judges in case of Minnesota elections to use as a guide. We think, and I'm reading from that opinion cited in Pavlak, we think that a statute prohibiting corrupt practices in elections and preventing any candidate employing corrupt means to obtain an office does not, in any proper sense, impose a new test of eligibility to office at all. It simply excludes a candidate employing unlawful means from enjoyment of a particular office under an election which his own unlawful acts have rendered of no effect. It prevents his reaping the benefit of his own wrong. It says not that he is ineligible to his office, but that he must use honest means to obtain it. And this is citing Saari versus Gleason from 1914, I believe. We do not disagree, Pavlak Court says, that Saari extends significantly the permissible scope of legislative activity in this area. No one would dispute the authority of the legislature to prescribe unfair campaign practices in the interest of promoting fair elections. But as Mr. Gleason's challenge implied, it is another matter to set aside an election in which such practices have taken place. Yet, the court in Saari logically and emphatically ruled that the power to promote fair elections necessarily implies the power to set aside unfair elections. Of what use would it be to assess a misdemeanor penalty against the offender of an election law while allowing him to hold the office obtained in part or by his very violation? An offender may not reap the benefit of his wrong, and unfair elections must therefore be set aside. This is not the addition of an eligibility requirement that is new. Rather, it is a recognition of the oldest requirement for democratic office of all. The candidate must have prevailed in a valid election. If he has not done so, he may not sit. Senator Franken violated election laws, but the Minnesota Supreme Court incorrectly concluded they could do nothing about it because the FCC had exclusive jurisdiction, they said, over the equal time requirements in the First Amendment in Minnesota elections for U.S. Senate. If the FCC said Senator Franken could do this, then no one in Minnesota could change it, they reasoned. But you as judges are clearly not bound by this legal reasoning. You have jurisdiction over this issue, and as the Supreme Court recently said in Sprint Communications versus Jacobs, quote, federal courts, it was early and famously said, have no more right to decline the exercise of jurisdiction which is given than to usurp that which is not given, citing Cohens versus Virginia from 1821. Jurisdiction existing, this court has cautioned, a federal court's obligation to hear and decide a case is virtually unflagging, citing Colorado River water conservation from 1976. Parallel state court proceedings do not detract from that obligation, and here there indeed is a parallel state court proceeding. This applies equally to you as judges, and I urge you to take jurisdiction over this case with your eyes wide open. If you allow this kind of conduct by all the congressional candidates in the nation, can you imagine what kind of precedent it will set? The destruction of the rights of independent voters and third parties by wholesale exclusion from all public broadcast debates because Democrats and Republicans control virtually all of the seats in the U.S. Senate. And the idea that you have established in the FCC a regulatory body that can preempt the field of political broadcast debates, neither you nor the FCC have the authority to regulate or violate the First Amendment in this way, as I have shown in the copy of the FCC disposition I forwarded to your Secretary of the Senate. But Senator Franken did not stop there. Realizing his political power and the apparent hopelessness of his IP opponent, contestant, in holding him accountable, he hired two Washington lawyers and a Minneapolis election lawyer to go into the election contest in Ramsey County and St. Paul and shut it down. he convinced the panel appointed by the Chief Justice of the Minnesota Supreme Court, again, that they have no power or duty to enforce Minnesota election law. His lawyers did this by a device of disassembling the Minnesota Statute 209.12 that guards your very power as the sole judges. And the Minnesota panel impermissibly made findings of fact and conclusions of law in the area that is your sole province. Would a real judge be allowed to actually do that? What kind of nation would we be if a circuit court judge with an interest in the outcome of a federal district court decision hired lawyers to go into the district court and control and shut down the proceeding so he would not face judgment? Under any kind of political system, that would be recognized as corruption. And each of you are involved in this issue. Each of you has to get elected in your own home state. And each of those state legislatures need to prescribe before any election what are the laws, what are the rules to play by. And in each of your states, there is a provision respecting the power of this body alone to sit in judgment of an election contest brought against any one of you. In Minnesota, the first sentence of 209.12 Congressional Office reads, quote, when a contest relates to the office of a senator or a member of the House of Representatives of the United States, the only question to be decided by the court is which party to the contest received the highest number of votes legally cast at the election and is therefore entitled to receive the certificate of election. The judge trying the proceeding shall make findings of fact and conclusions of law upon that question, unquote. So Senator Franken and his lawyers first argued, dismiss this contest because it doesn't show any justiciable claim under Minnesota election law. Dismiss the contest. I don't carry out your duties under the U.S. Constitution, Franken told them. Or actually said, instructed them not to carry out their duties under the U.S. Constitution. But then he came back later and said in a letter I never saw, instead of dismissing the case, let's just read the first sentence of 209.12 and ignore the rest. That will get rid of that pesky contest. We know this Carlson is a habitual litigator, so just decide, even though Carlson's not contesting it, which part of the contest received the highest number of votes, and, quote, is therefore entitled to receive the election, or the certificate of election, unquote. Well, if the panel decided Franken got the highest number of votes, then we must decide Franken is entitled to the certificate of election, is what he argued. And Judge Vandenorth, after limiting the trial, quashing all discovery, in fairness, he quashed it saying that you of the U.S. Senate might investigate and allow an alternative to the state court discovery proceedings, and saying, let's get this railroad started. That's what Judge Vandenorth said, and just decided to allow Franken to forward just this election certificate. Then, said Franken's attorneys, we can talk about Carlson's issues. But there's a problem here. The proceedings instigated in the Minnesota court was not a discretionary recount or any kind of recount, and so there was no question that if there were no other points, Franken would get the certificate. But the Minnesota statute goes on. Evidence on any other points specified in the notice of contest, including but not limited to the question of the right of any person to nomination or office on the grounds of deliberate, serious, and material violation of the provisions of Minnesota election law, must be taken and preserved by the judge trying the contest or by some person appointed by the judge for that purpose, but the judge shall make no findings or conclusions on those points, unquote. Now, this part of the statute clearly exists to protect your role as judges on any other points. And by the way, you are the judges of the count as well, and whether the voters voted lawfully. But I'm not saying anybody committed fraud in voting. That's not the purpose of this contest. And any other points includes the enforcement of the election laws against violation by Franken or anyone else. It is not the case that if Franken can't be connected with the serious material and deliberate violation, he's home free. Again, the important Minnesota case Saari versus Gleason, which clearly extends the job of the Minnesota courts beyond just the ballot-related issues, reads, quote, "Of what use would it be to assess a misdemeanor penalty against the offender, here Al Franken, of an election law while allowing him to hold the office obtained in part by or his very violation?" So either he contributes to it or it's just his violation. This says, quote, "in part by or his very violation," unquote, of election law. And then he has lost his right to office. Under Minnesota law, according to the Supreme Court in Saari and in Pavlak, there's no doubt that Senator Franken contributed part of that violation which bars him from the office. It's true that the DFL, in its control of the legislature, established this requirement of the principle of gender, race, and sexual practice quotas and other quotas, which violated the 15th and 19th Amendments by depriving white men as a group and individually of their right to vote in precinct caucuses, and really deprived all Minnesota voters of their individual voting rights and replaced them with group rights. For instance, a woman might argue that she does not agree with all the other women and wants to make decisions on positions or candidates for the DFL with all the other eligible voters in the precinct, in which every voter has an equal chance of influencing the decision and moving on to vote for the state endorsement without regard to their gender, race, or sexual practices. She would lose that right under the DFL system. She must bond with women and accept that men will be limited by state law in their participation. Franken may or may not have had anything to do with that. We know he's aware of it because he's subject to the rule, is responsible for knowing, because he's required by law to agree with it. So even though the debate violation is just a part of the violation, if we consider he agrees with the so-called principle of the Minnesota voter quota, the caucus issue, he is responsible for another part of it now. And maybe Franken didn't know that his partisan Mark Ritchie, as chief elections officer, took home voter and donor email addresses from the Office of Secretary of State to use in his own campaign. And then I want to switch, but it doesn't matter because he's already contributed to part of this violation, this invalid election. Now the Minnesota courts is another part, and as I set out in the election contest, I sent each of you through the Secretary's office. They have completely abdicated their responsibility, allowing the blocking of a contest on grounds 1 and 2, which are the caucus violation and the email violation in 2012. And this was in violation of the duties under the prescribed laws of the Minnesota courts. And in effect, they made conclusions of law that no serious material, deliberate issues of election law violation could come to the real judges, the U.S. House itself. They relied on the pretext that I had to pay some hundreds of dollars, and that was wrong. I got past this hurdle in 2014 by standing at the clerk's desk in Ramsey County and directing them to consult the Supreme Court. And the Supreme Court did allow this election contest to proceed without payment, and none is required, but only so far, until Franken's attorneys moved in and shut it down, using inter alia a letter from your secretary stressing just how important it was that Senator Franken reach Washington on time and ignoring the other points, like valid elections. And this violates the U.S. Constitution just as surely as it did when the Georgia legislature allowed black voters to be assaulted to keep them from voting in the Democratic elections there. And it's because of Article 1, Section 4, that the Minnesota legislature shall prescribe the time, place, and manner of selecting the U.S. Senator from Minnesota. And then that prescribed manner, including enforcement by the state's judiciary, shall be enforced and followed. And here is a judge, Senator Franken, dispatching his lawyers to St. Paul to make sure those laws are not enforced. To the extent Senator Franken and his lawyers could have been even genuinely confused about the construction of the law, that does not make his interference in the carrying out of the Minnesota election law any less deliberate. Deliberate does not require intent or malfeasance, just that the action is deliberate. And it's material because it prevented the evidence from being collected and passed on to you. At this point, no discovery has been allowed, and Mark Ritchie backed this, just as Mark Ritchie backed the action by the Ramsey County Court of blocking my timely contest against Betty McCollum in 2012. And it's serious because these are violations of the U.S. Constitution we're talking about. And violations of the Minnesota Government Data Practices Act are also serious. But the Constitution constitutes or establishes the United States, and this U.S. Senate, you have a duty to enforce it, including the right to vote and the First Amendment and other constitutional requirements mentioned. Once fixed and officially established, the requirements of the Minnesota legislature, including the regulations of this august body and the U.S. Constitution, like the 1st, 14th, 15th, and 19th Amendments, are not allowed to be altered and must be followed by the Secretary Ritchie, the Minnesota Supreme Court, Senator Franken's campaign, and the Minnesota DFL party, Mike McFadden for the GOP of Minnesota. For the Constitution, quote, adopts the state Minnesota qualification as the federal qualification for the voter. But his right to vote is based upon the Constitution and not upon the state law. And Congress has the constitutional power to pass laws for the free, pure, and safe exercise of this right. That's from Ex parte Yarborough from 1884. And again, this body's power derives not even from itself, but from the Constitution. So the Saari precedent in Minnesota law is an important guide to how you should decide this case. So is Anderson versus Celebrezze, which I discussed in Part 3 of this U.S. Senate statement. I want to come back to it now and look at its key finding and how it applies to this contest. So the other point I want to make before I leave you in this proceeding, senators and judges, is that you have a duty to ensure that the First Amendment rights of independent voters in Minnesota and across the nation are protected. The violation in the U.S. Senate race, and the Secretary Ritchie has correctly observed that if this case is resolved by a finding that the U.S. Constitution has not been followed and must be, then that will impact all candidates and campaigns for federal office, not just Senator Franken's and not just mine. And the violation has been a combination of Franken's actions, his party's, and partisans' actions in state action. State action is involved in requiring gender, race, and sexual practice quotas to restrict voting and participation in the precinct caucuses. Specifically, I'm reading Minnesota Statutes 202A.16, caucus, who may participate and vote. And under Subdivision 2, agreement with party principles, so we know that Senator Franken agrees with this and is knowledgeable and is doing this deliberately. Only those persons who are in agreement with the principles of the party as stated in the party's constitution and who either voted or affiliated with the party at the last state general election or intend to vote or affiliate with the party may vote at the precinct caucuses. And here's the principle expressed in the Constitution. Dated December 2014, it still requires Article 1, General Rules and Policy Principles. Section 1, Outreach and Inclusion. The state party chair and other DFL party officers at every level shall, by affirmative steps, including outreach and inclusion, encourage young people, the elderly, women, the handicapped, and minority groups, whether by race, ethnic groups, or sexual preference, to attend the precinct caucus and to seek election as delegates, members of party committees and officers, and they will inform all persons how to effectively participate, which will include suing or challenging delegations in the selection process, and encourage all Democrats to select affirmatively such individuals when voting. So in other words, vote for them, so that such groups shall be on such delegations in committees and in party offices in reasonable proportion to their presence in the state. And this includes the voting delegations. These affirmative steps shall provide a basis for review and challenge of the officers and delegations, voting delegates, as specified in the bylaws and printed in the call to convention. And the outreach, so this goes all the way up to the state convention. Outreach and affirmative steps for inclusion shall be explained at the precinct caucuses, where I have heard them, and any higher level conventions, and shall be included in the DFL call to conventions. Now, Secretary Ritchie's challenged actions also, including his ethics admonishment for denying that he had taken home voter and donor email addresses to help his campaign, but also when he reversed the practices of Nancy Bream to make voter email addresses available to all candidates so that they were no longer available, although he claimed discretion to make them available if he chose. This was all state action. And finally, the refusal by the state courts, with approval and cooperation by Secretary Ritchie and the advocacy of the Attorney General, to not follow Minnesota election laws and enforce the U.S. Constitution and Minnesota prescribed election laws. This was all state action. So what was done to the Independence Party, to independent voters and the IP candidates and nominees, including contestant, was action the state must justify under Anderson versus Celebrezze, because clearly they are burdens, unreasonable, and injurious burdens to our First Amendment rights that were imposed on us. The Independence Party was excluded from debates for statewide office, the very offices we needed to do well in to remain a major party. I was allowed to debate for the CD4 race with Betty McCollum in 2010 and 2012, but my achieving 6% or more in each election did not count towards the party's continued status, because it's not a statewide race. This was a burden imposed by the state in refusing to enforce the very same laws that they did enforce in Moore versus NPR in 2002. There is no justification, and has been none offered, for restricting the Minnesota Supreme Court's jurisdiction to just ballot issues. And remember what the Supreme Court said about not exercising jurisdiction that's given to them, while other violations would go unchecked. No justification was made for pretending Betty McCollum was entitled to office, even though the state law provided for election contests against her, in applying equitable remedies like latches instead to the statutory time period for election contests. In other words, that's statutory. I have 7 days until the canvassing board acts to file that contest. It's not governed by latches. Or for requiring a fee to file. There's no justification. Or for not making the Ramsey County Court process the elections contest in 2012, just as this one was in 2014. Or for the roadblock, keeping back the evidence and debate, the transcript, record, and evidence from this body of judges with sole authority, this done by the panel. So it hurt us just the same way that these violations, that Ohio would have hurt John Anderson if they kept him off the ballot in Ohio. We're kept off the ballot by these practices in 2016 if this challenge is not upheld. The big national parties have a big advantage in spending over the Independence Party and other third parties, and they purchase email addresses for millions of dollars, according to Ritchie and court filings. And to protect this industry and this disparity in access to voter emails puts a burden on less organized voters and parties, even if it was true that no Democrat other than Ritchie ever got access to voter emails addresses. The arguments presented by Ritchie in courts to get around the fact that all data collected by the state is presumed public unless specifically classified by the legislature otherwise is unjustifiable. The collection of email addresses is not even included in the provision they claim shows the legislature